I'd like to welcome everybody to today's real estate section program for the Beverly Hills Bar Association. My name is Howard Gould. I'm co-chair of the real estate section for the Beverly Hills Bar, and we're very excited to be presenting a program on the AIR, commercial real estate standard offer and purchase agreement. Before we get to the program, a couple of announcements. I'd like to tell you about the next 3 or 4 programs that this section is going to put on. On July 29th, we're doing a program that we've never done before. The general nature of it is to talk about the fire maps that have come out from the state, fire resiliency, insurance issues. Our speakers are going to be Michael Lynch from Marsh & McLennan, insurance advisory firm, and Don Schmitz, who has a land use firm here in the Los Angeles area and has a great deal of expertise about fires. I have heard Don talk before. Larry Hummer and Joe Colbert are putting together that program for us. On August 8th, it's not our usual third Thursday, but August 8th, we're going to do a program called Cash for Keys. Last month in May, we did sort of a tenant program talking about landlord-tenant issues and a new study that had been done regarding the handling of landlord-tenant cases in the Los Angeles Superior Court. We're going to switch to the landlord side in August and talk about landlords buying out tenants and why sometimes it makes a lot of sense, even though they may be paying $50,000, $100,000 or more to a tenant to move out of a residential unit. We're going to have on the financial side, Ellie Appel from Marcus and Millichap explaining why the economics work, even if a landlord sometimes is paying a very large sum of money to one or more tenants to get out, and how it actually increases the owner's equity in the property and cash flow. And then the principal speaker is Sasha Struthers, who has a law practice that is basically nothing but cash for keys, where she assists landlords in doing the buyout because you do have to comply with the technical requirements of whichever jurisdiction you may be in. September, we're going to do a program pretty unique for real estate section, which is the intersection of intellectual property law and real estate. Something people don't really think of as having much relationship to each other, but we're going to have Lindsay Karotkin and her partner, Sarah Albertson, I believe it is, from Errant Fox's New York office, talking to us about intellectual property and real estate. And Lindsay has published an article on this subject. And then one of the programs in the next couple of months, haven't decided exactly which month, we're going to have a program about risk management for lawyers, basically something like an ethics program. And the former president of the State Bar, who I've known for many years, Heather Rosing, who has recently started a new firm in San Diego, is going to be our speaker for that program. There's a link to the materials for today's program in the chat, and we're going to use the Q&A function, not the chat, for questions. So if you have questions, please post them in the Q&A, and I'll be looking over those and try to bring them up at the appropriate time in the program. It's a great pleasure today to again have Bryan Mashian of the Mashian Law Group as our speaker. Bryan talked for us last year about the AIR lease form, and this year he's going to talk about the AIR purchase and sale agreement form. And he's the perfect speaker for this because Bryan is counsel to the contracts committee for AIR commercial real estate. He speaks on at AIR events and is a perfect person for this subject matter. He's been on this executive committee for this real estate section and chaired this section for the Beverly Hills Bar. He's been on the steering committee of the commercial development and leasing subsection of the real property section of the Los Angeles County Bar Association. He's a member of a number of industry groups, including the International Council of Shopping Centers, ICSC, the editorial board for the Shopping Center Law Report, BOMA, the Building Owners and Managers Association, and the National Association of Corporate Real Estate Executives. Bryan did his undergrad in economics and political science at UCLA, and then also went to UCLA Law School, where he was editor of the Law Review. and his prior law firm affiliations before founding his own firm in 2006 were included Dern, Mason, Swerdlow and Flom, Shea Gould, and Buchalter, where he was head of the real estate department. Bryan's published numerous articles and had a lot of speaking engagements. And Bryan, thank you so much for joining us today.
The pleasure. Thank you, Howard. And I'm going to start by sharing my screen, and hopefully this is working. And so today I'm going to talk about the 10 topics in negotiating the AIR purchase and sale agreement. And this is the standard offer agreement and escrow instructions for non-residential. As you may all know, we publish 3 varieties. One is this contract, and one for vacant land, and another one for multifamily, 5 units or more. They're all pretty much structured the same way with some nuances for the property type. But so in talking about the 10 topics, one of the questions that comes up quite a bit is this a purchase and sale agreement? Is it an option? Is it a contract? What is it? So the purchase and sale agreements have a series of due diligence contingencies. And the way the contract is structured is that the closing date for the escrow is a number of days after the actual or deemed satisfaction or waiver of the buyer's contingencies. So the way the contract is set up is that the buyer has a quote unquote free look during the due diligence period. The buyer can disapprove, and the earnest money is refunded to the buyer, and the parties walk away. Years ago, in 2010, the Supreme Court decided the Steiner versus Thexton case. And in that case, the buyer contracted to buy a 12-acre piece, buy 10 acres of a 12-acre piece. The buyer was supposed to do this parcel split at buyer's expense, and the buyer could cancel the contract in buyer's sole and absolute discretion. After the parties signed the contract, the buyer spent about $60,000 and completed most of the approval for the parcel split. Then the seller decided that, no, this is not a contract, rather it's an option in favor of the buyer. And since the seller wasn't paid a separate consideration by the buyer, that it was not an enforceable agreement and the seller could revoke it, which is what the seller did. Then Steiner, the buyer, sued. The case worked its way up to the California Supreme Court. And the California Supreme Court said, yeah, the contract is called a purchase contract, but we're going to go past the title and we're going to look to see what the contract really functions. How does it function? And the fact that the court noted that the agreement was in fact an option contract because only the seller was bound while the buyer retained full discretion to withdraw from the sale. And the buyer's initial promise to seek approvals might have been illusory because initially buyer hadn't done anything, hadn't spent any money, hadn't spent any effort. And the court noted that the express language in the contract overrode the implied covenant of good faith and fair dealing. Ultimately, the court ruled that the option was an irrevocable contract because there was sufficient consideration, and the consideration was the substantial performance provided by the buyer. That was the bargain for consideration that the parties had a meeting of mind about. And that's the reason that the buyer spent significant amount of money and went through and did 75 to 90% of the parcel split work was done by the buyer by the time the seller revoked the contract. And the court noted that that was the party's bargain for consideration, and the fact that the buyer subsequently provided that bargain for consideration cured the defect and made it a binding contract. And the court also noted that the parcel split benefited the seller, who was retaining the 2-acre piece that it could then subsequently sell. So after that case came down, the contracts and the AIR contracts were revised to add the section 4.4, which you'll see in a lot of even tailor-made contracts that are prepared by lawyers. It basically says that the escrow is supposed to release $100 of the deposit, of the buyer's deposit, to the seller as an inducement for an independent consideration for seller entering into the contract with the buyer and giving the buyer the contingency period to do due diligence. And this $100 is not refundable to the buyer, but is credited toward the purchase price at the closing. So this is like an insurance clause in the contract to make sure that a disgruntled seller can't come back and subsequently say, hey, because this contract really gives the buyer a free look, this is an option, it's not a binding contract, and try to get out of it. So, as I mentioned, the contract in section 9.1 has quite a few set of contingencies, and the closing date is keyed off of the satisfaction or waiver, or actual or deemed satisfaction or waiver of the buyer's contingencies. 9.1A is where the seller is required to provide the mandatory disclosure statement and a property information sheet. The buyer has an physical inspection under subparagraph B. The buyer has a right to do a hazardous substance condition report, or phase 1 or phase 2 report. The buyer can do a soil inspection, seek government approvals, review and approve of title, which includes the underlying documents and a scaled and dimensioned plot plan of the easements, and conduct an ALTA survey, and do review the leases and Estoppel certificates. The owners association, if this is part of a condominium, is also another contingency where the seller is supposed to provide some of the documents related to the property owners association. Other agreements such as management agreement, parking service agreement, etc. And then finally, contingency for new loan financing is part of the overall contingencies for the buyer. The buyer taking over existing notes, either assuming them or taking it subject to, is 9.1L. And finally, it's buyer to review and approve of the personal property that's included as part of the sale. Most of these have a start date, which is from the date of agreement or from the seller's delivery of the applicable due diligence document. From the buyer's perspective, it's let's talk about how would a buyer expand. And obviously, a seller is going to try to tighten these contingencies. What our contract does not call for is a rent roll. So a buyer can add for a rent roll certified by the seller. This is really more appropriate for, let's say, an apartment building in a multifamily where there's a lot of units, and the buyer wants the seller to provide a rent roll that says how much is the monthly rent, how much is the security deposit, who's current on paying the rent, et cetera, et cetera. So this is a perfectly good addition by a buyer. Whether the seller is willing to do it or not really depends on, a lot of these depend on who's got the leverage and matter of negotiation between the parties. One other item for a buyer to add to expand the scope of buyer's contingencies is to add a requirement for the seller to provide a schedule of the leasing commissions and a copy of the agreements that the seller has with the current brokers. So the leasing commissions could come into play, for example, for existing leases that have been signed, and there may be commissions due to brokers still under those existing leases, or if a tenant exercises an option, there may be a broker who may be entitled to a commission. For example, if a tenant exercises an option to extend the term of a lease, then the broker may be entitled to a additional commission. So from the buyer's perspective, it's a perfectly good due diligence item to determine what are the potential commissions that may be payable by the buyer as the then owner of the property if a tenant exercises an option to extend, purchase a right of first refusal, right of first offer, purchase option. That's a good add by buyer. We see in a lot of attorney-prepared contracts that the seller is required to provide the property taxes. It's not in part of the AIR contract, but it's a good add to get the property tax bills for the past 2-3 years. It's helpful to a buyer to see what those current taxes are and how much is the likely increase in the assessed value of the property after the sale is closed. Next is the financial information, such as the operating statements that the seller has for the past 3 years owning and operating the property. This is very valuable information to a buyer who can determine what's the typical cost to maintain and repair the property. What is the typical utility expenses that run? And this is very helpful for projecting the income in the future during the buyer's ownership of the property. Next is the seller's liability, fire and casualty insurance. Today, with the insurance business being so different and so some properties being so difficult to insure, it's very helpful for a buyer to get the seller's liability, fire and casualty insurance policies and determine whether they can actually, whether the buyer can take over those policies, or this is going to be cost effective. Can the buyer actually get insurance? This has become a real issue, and whether I see some buyers adding as a contingency the ability to get insurance at reasonable premiums as a contingency to the deal. Continue with the list of the buyer's contingencies, getting copies of the certificates of the tenant's insurance policy. So if you want to find out how much insurance does the tenant carry, and that's going to be very helpful for the buyer to determine what kind of insurance the buyer may want to carry. Next item is materials regarding condition of the property, and that's the seller's phase 1 or phase 2 reports that the seller may have. Now, section 9.1D of the purchase and sale agreement requires the seller to provide a copy of the soil report, but that's different than the phase 1 or phase 2 report. So if there is a phase 1 or phase 2, arguably, if they show bad facts about the property, if they show that there's potential contamination, the seller would be duty bound to disclose that anyways. But it's always a good idea for a buyer to ask for the seller to provide a copy of a phase 1 or phase 2 report that the seller has in their control and possession. Next is a list of license and permits that benefits the property, especially if there's conditional use permits or very unique permits that are applicable to this property. Those are always good to get copies of those licenses and permits. Any plans, drawings, and specifications that the seller has for the property. This is invaluable for the property management and for doing remodeling or construction work post-closing. Having those plans and drawings is very, very helpful to the building engineers and also to the architect if there's going to be a remodeling. Next is the list of warranties. What are the warranties with respect to the heating, ventilation, and air conditioning system, the roof, and if there was a contractor who did some work, what is remaining on the contractor's warranty? Finally, a zoning verification letter from the city, the municipality, regarding the property's current zoning and compliance with laws. This is a great item to get, as you need the zoning verification letter to get the title insurance company to issue a zoning endorsement. There's a little bit of a ramp-up time. You have to remember to do this with this municipality right when you open escrow, so it doesn't jam you up and you run out of time. From the seller side, the Estoppel certificates are a critical item because, as I mentioned earlier, providing Estoppel certificates is a due diligence contingency. So if you have a property that has obviously a lot of tenants, that's going to be a lot of work for a seller to go get Estoppel certificates signed by every tenant, not knowing whether the buyer is actually going to go through with the deal. So quite often people would revise the Estoppel certificate arrangement to change it from a due diligence contingency to a closing condition. In other words, the buyer signs off on all the other contingencies, and a condition to the closing will be the seller to deliver Estoppel certificates that are clean, or there's some other definition of the Estoppel certificate form that's going to be acceptable to the buyer. So this is something important if you have a lot of tenants in the project, and from a seller's perspective, it's a very helpful change to make so you don't end up spending a lot of time getting these estoppels and the deal then doesn't close for some other reason.
Bryan, do you see many cases where the seller just can't get estoppel certificates, and what generally happens then?
Well, in the AIR purchase and sale agreement, the contract allows the seller to deliver an estoppel certificate instead of the tenant. If I'm the buyer, I would not be too happy with relying on a seller estoppel certificate, since that means that if the seller's misrepresented the state of the lease in the seller's estoppel certificate, then now I have to sue the seller for breach of warranty, etc., and that's just buying a lawsuit. The fact that a tenant refuses to give an estoppel certificate is a telltale sign that there is a problem there. So that should alert the buyer right away to find out what's really going on with this tenant and what's the reason that the tenant is refusing to give the estoppel certificate. So if you have to rely on a estoppel certificate, it'd be good to combine it with some kind of a holdback in escrow so that there's some of the money held in case there's a breach of the seller's statements in the estoppel certificate. So there's something securitizing that seller estoppel certificate. As I mentioned earlier, the contract gives the buyer a free look. And as a seller, you may want to change this to have that buyer actually perform due diligence. For example, doing an inspection or adding a provision that the buyer has to use commercially reasonable efforts. I've seen this quite often with getting a loan, and have the buyer submit loan application and provide seller copies of the loan applications, etc. Or you want to get a pre-qualification letter before you accept the buyer's offer. My experience has been that with these kind of additions, what you're inevitably going to end up with is a dispute as to whether or not the buyer did meet the requirements in the contract that you've added. And oftentimes that ends up prolonging a termination of the contract. When the buyer has decided not to buy and the seller is trying to get the buyer to forfeit a deposit, it ends up prolonging a dispute and puts a cloud on title of the property when the seller wants to sell it to the next buyer. So I don't see this happening quite a bit, where people actually require a buyer to do this kind of a commitment to perform due diligence. In long-term escrows, for example, if there's an entitlement deal where the land is being subdivided and the developer is a home builder who's going to go through the parcel split and get the entitlements to create the subdivision, it's pretty typical to ask the buyer to pay as you play. So the longer that the property is tied up in escrow, the seller will require the buyer to either put additional deposits into escrow or have the buyer pay those additional deposits to seller outside of escrow in order to have more due diligence time or extend the closing date. That kind of that change is where the rubber meets the road. If the buyer is really interested in still pursuing the deal, then they will put up the additional money. If they're not, then they'll cancel and they won't waste any more time. One of the things that I've seen happen quite often is where people have this additional deposit. They're not very clear as to what is this additional money for. This also happens with deals where the parties sign and go hard, which is not happening in today's market. It was very prevalent 3-4 years ago. You have to be clear about what this additional money is for, and oftentimes it's money that's given by the buyer to the seller to either extend the due diligence period or extend the closing date. And when the buyer makes those payments, that has been earned by the seller. And you want to make sure that you don't characterize it as liquidated damages, because that only gets paid to the seller if the buyer has signed off on all the contingencies and fails to close on the scheduled closing date. And it's important to make sure you properly characterize the application of the money and what it's for, and is it refundable or not, and is it applicable to the price. Let's talk about the retrade process. And what I mean by the retrade process, it happens pretty much in every deal where a buyer does an inspection, comes back and says the roof needs to be replaced. I want a $50,000 price reduction or a credit. So Section 9.1 of the AIR contract provides what we call is a passive approval, meaning if the buyer does not actively disapprove of a contingency, then the buyer is deemed to have approved of that contingency. So it's important for the buyer or the buyer's broker to make sure that they closely monitor the due diligence timeframes to make sure they don't inadvertently allow a contingency to become approved or deemed approved. So the way the contract works is that buyer's disapproval or conditional approval is considered a disapproval. Now, the buyer concurrently with the disapproval or conditional approval can ask for price reduction or credit, can ask the seller to perform some kind of repair, ask for more time for either the contingency or more time for closing or anything else. If the buyer just disapproves and doesn't ask for anything, then the contract is over. Then the buyer is refunded its money, the parties part ways, and the contract is over. If the buyer does ask for some repair, price reduction, more time, etc., then the seller has 10 days to respond to the buyer's request. If the seller accepts the buyer's request, that automatically amends the contract. So you don't have to go through the process of getting escrow to prepare a separate amendment. The acceptance automatically amends the contract, provided the seller's acceptance of the buyer's request is without modification. If the seller doesn't do anything, is silent for 10 days, then the seller is deemed to have rejected the buyer's request, and then the buyer then has 10 days to decide to cancel the deal and get its money back, or accept the seller's response if there was a response, or withdraw buyer's request and go back to square one. So ultimately, the buyer is the one who's driving this process. The buyer gets the last word in this back and forth. And the reason for that is the buyer who's more likely to be at risk and more likely to be suing. So this gives the buyer a lot of leeway to try to renegotiate something that the buyer's unhappy with. A lot of sellers don't like this back and forth. You can eliminate this back and forth altogether and modify the contract, provide that if the buyer disapproves, the contract is over, or reduce the time frames. Now, the time frames can be reduced pretty dramatically, and it probably is not an unfair thing to a buyer, because most buyers really don't need that much time to approve. But the reason these timeframes are so long is to allow the parties to work out a deal. So if you, as a seller, you think this is too long, you can modify the contracts by going in there and altering the actual text of the contract to reduce the timeframes or eliminate this back and forth process altogether. So here's a chart that summarizes this process that I just described. If the buyer does not disapprove, then the buyer is deemed approved, and the contingency is waived. If the buyer disapproves, if the buyer doesn't make a request, the contract is terminated. If the buyer does make a request, then it's up to the seller to accept, in which case the contract is modified. If seller rejects or does not respond, then the buyer can withdraw the disapproved item, or the buyer can cancel the contract and get its money back. So this is in there primarily to make sure that the deal can be made, which is really beneficial for the buyer and the brokers, because the brokers are the ones who worked hard to put the deal together, and they don't want to see the deal evaporate into thin air just because the seller has and the buyer have something to work out as a retrade process. The next point to talk about is the closing costs. Our contract, the base contract, is the Southern California custom for splitting closing costs. The escrow charges are split 50-50. The seller pays the recording fees. The seller pays the documentary transfer taxes, and that includes the ULA or the mansion tax. And the seller pays for the standard title insurance policy premium. The buyer pays for the upgrade to an ALTA policy, and it is very, very important for a broker or lawyer to pay attention to this section if you're doing a deal in Northern California or you're doing a deal in another jurisdiction. By the way, the AIR contracts are now available in, I think, 48 out of the 50 states. They'll be available in all 50 states pretty soon. And it's important that if you're doing a deal outside of Southern California, to modify this split of closing costs to match the local custom. And the local custom can significantly cost you or save you money. Either you're the buyer or the seller. It's very important to pay attention to this. It's significant. Monies could be affected by the conforming the closing costs split to the local custom.
anyone who does much residential work will note that during the pandemic and with the last big change in the CAR purchase agreement, they moved more in favor of the sellers and really away from benefiting the buyers so much. Really, in my view, to the detriment of buyers in what had become really a seller's market during the pandemic when so many people were trying to find new places to go. And so you need to be careful to make certain that you look at what's in the commercial contract that AIR has, because they haven't necessarily behaved the same way that CAR did during the pandemic.
Our contracts are modified based on input from our users. We do not often make changes to the contracts based on what's happening in the market. And they have worked well both in the up and the down market, and we haven't had the need from our customer user base to make those kind of changes. Let's talk about sellers, reps, and warranties. And this is obviously a favorite topic for lawyers. And Section 12.1 of the Purchase and Sale Agreement has a list of areas that are warranted by the seller. I would say this is a healthy list. It's not the most exhaustive list. Obviously, as a buyer's lawyer, you can supplement and expand this to include topics that are applicable to a particular property. But generally, Section 12.1 deals with the authority of the seller, that the seller has the right, power, and authority to enter the contract and consummate the transaction, that the seller will maintain the property pending escrow, the seller is unaware of any hazardous substances, that the seller, to the best of the seller's knowledge, the property complies with all applicable laws, the seller will not change the leases or any other agreements while the property is in escrow, that there are no other leases, there are no mechanic liens, no lawsuits, no tenant bankruptcy, and no lien on the personal property. So what's important to, as a lawyer, ask yourself, are we using the purchase and sale contract that's published by the AIR to try to streamline and accelerate the deal? Or is this just a starting point to start heavily negotiating? And I've seen both, and I'm sure everybody in the audience has seen where you start with a printed document, and then it gets ripped to shreds, and the addendum is much longer than the actual contract. So what the AIR has done is try to provide a set of warranties that if a buyer was represented by competent real estate counsel would get from a seller who was represented by a competent real estate counsel. Is it everything that a buyer would ask for? No. Does this mean that the seller has to agree to all of this? No. But here's the reality of how this plays out when you go to negotiate. Once you strike or modify one of these, inevitably, either the lawyer for the other side or the principal of the other side will look at what you changed or what you added. And that becomes the bone of contention. And while there's no standard for what is a usual set of reps and warranties, these warranties have stood the test of time for many years to be good enough for a buyer and a seller. It's not too much to the landlord, not too much in favor of the buyer, not too much in favor of the seller. So the contract provides that the warranties survive for 3 years after the closing. Obviously, this is not the law in California, which is 4 years for breach of contract, but it's there as a placeholder to remind you that if you want to modify, and this is something that gets negotiated in attorney negotiated purchase and sale agreements, how long is the seller's warranty going to be good for? So it's there. If you want to modify it, you could reduce 3 years to 6 months, or you want to lengthen it you can do that too. From the seller's perspective, you want to reduce the duration of seller's warranties. And from the seller's perspective, you want to eliminate as many as possible to reduce the seller's exposure for having made these representations and warranties.
Brian, this may
Yeah.
be a good place for the question we have in the Q&A, which is, do you routinely see buyer's counsel use a very custom form of agreement, especially maybe on deals that are 10 million and above? And then if you represent the seller, do you try to convince counsel for the buyer to use the AIR form, and why or why not?
For larger deals and more complicated deals, I see the tailor-made contracts being used more often. But I myself have done many what I consider to be large leases and purchase and sale transactions using the AIR contracts. They work just fine. And they actually help limit the negotiations between the lawyers by giving you the basic framework of an agreement. And you focus on what specifically needs to happen in this particular deal. So for larger transactions, I think sometimes parties want to have document control, Howard. They want to assert their leverage, especially in today's market where it's a buyer's market. So I've seen pre-printed contracts like the AIR used, for example, by somebody who puts an addendum on it that becomes so onerous that they might as well use the tailor-made contract, that it wouldn't have made a difference. So if you're going to go use the AIR contracts, try to stick with what the point of it is to streamline and to streamline the transaction and avoid a lot of unnecessary negotiating. But again, that's a question of market, who's got the leverage, and who wants to deal more badly, right?
I think one other big benefit of using the AR form agreement is because if real estate lawyers tend to be familiar with them, some of the buyers and sellers are familiar with them, and you know where to find particular points. Whereas even if there's a long addendum, hopefully the addendum relates to the specific point and heading that was in the AIR contract, so you know where to find things. Because otherwise, if you have a custom agreement that's really long, you may not remember where something is in that agreement when you go back to try to deal with it.
Right. If you use a custom agreement, the one who prepared it and is their form has the upper hand. They have so much more information about the contract that it gives them a real leg up in the negotiation. And using the pre-printed AIR contract does sort of even out that playing field. So it's not completely lopsided like it is when you start with the other side's form. And I've seen it where sometimes it actually doesn't help to use a pre-printed form where it gets so heavily negotiated, then it becomes kind of clunky negotiating the contract. So sometimes it may make sense not to use it and just go to a tailor-made one. But if you're going to use the pre-printed, try to not to just undermine the whole purpose of it by having a lot of changes or a huge addendum.
And make certain that the changes relate to the section in the AR contract that already addresses the subject matter, so it doesn't get too confusing to find.
Right. So in the AIR contract, quite a few of the representations and warranties are limited to the seller's knowledge, and it's very commonplace to have a seller define seller's knowledge to be the actual knowledge of a particular identified person who works in the seller's organization. So, and that duty, that knowledge is without any duty of inquiry or investigation. So it's what that person actually knows at the time the contract is signed. And this is a typical ad that I see, and I don't think it's unfair for a seller to add this. It also disclaims the knowledge of sellers, other agents, and employees or principals. This provision also typically says that the person who's named in the contract doesn't have any personal liability if it turns out that the warranty was breached. Rather, it's the selling entity that's going to be on the hook, not the individual. One thing to pay attention to is section 12.3 provides that if the buyer closes after the buyer has learned the rep or warranty is incorrect, that equates to a waiver of the seller's breach. Now, in California, there's a split of authority on this issue of whether or not a buyer waives a breach of warranty by proceeding to close or not. And I think as a buyer, you may want to be able to sue and not be deemed to have waived the breach of a warranty. So you can recover damages that may be due because of the misrepresentation or the misleading of the buyer to enter into the contract. And then the buyer was stuck in a bad position where they had to close the deal, or they would end up suffering significant damages. So 12.3 is something that as a buyer, it protects the buyer. As a seller, you may want to flip it and till there's some kind of a resolution of the split of authority in California. Our contract says it's a waiver, which is more in line with what a ordinary person would expect, that if you knew a rep or warranty was incorrect and you bought, then you assume that risk. The seller also provides under our contracts 2 other documents that are part of the disclosure. The first one is the property information sheet. In this property information sheet, it basically is a list of the different components of the property, and it requires the seller to tell the buyer of any defects that the seller is aware of in that part of the property. And it covers the equipment, the condition of equipment, soil problems, insurance claims, violations of any laws, any hazardous substance contamination, or any storage tanks that were on the property, any fire damage, any unrecorded title exceptions, and the leases. So this is the property information sheet. The second item that's required by our contract to be provided by a seller to a buyer is what's called the seller's mandatory disclosure statement. The seller's mandatory disclosure statement basically is to fulfill a seller's duty to disclose things that the law requires be disclosed by a seller to a buyer regarding whether or not the property is, for example, is in an earthquake zone, or in a high fire risk zone, or a flood zone. And it requires the buyer be provided a earthquake booklet and be notified if there was flood disaster insurance, and water heater bracing has been done if there's any mold, and there's a notification that's required to be given by law regarding title insurance. The seller's mandatory disclosure statement, as the name implies, is the seller's statutory duty. And a lot of this is taken care of by this cottage industry that's popped up many years ago, where natural hazard disclosure is provided by the seller as part of the seller's mandatory disclosure statement to the buyer. The property information sheet is meant to satisfy the seller's common law duty of disclosure of defects that are known to the seller that would affect the value or desirability of the property. So these two, combined with the seller's warranties, and there is some overlap between the information that's in the seller's property information sheet and the seller's warranties in the body of the contract. So a lot of people will add to the contract as is. And section 12.2 is the closest thing we have in the contract to, an as-is provision. Section 12.2 says that the buyer is buying the property in its existing condition and will have either done its investigations or waived those investigations that it thinks is necessary to protect itself. And the seller buyer acknowledges that there's no other promises besides what's in the contract. What does as is mean is, if you read the cases, they basically say that's supposed to alert a buyer that the buyer needs to do more diligent and thorough investigation. Commonly, there's a misunderstanding that, not amongst the lawyers, but a lot of brokers think that if you sell something as is, you no longer have a duty to disclose the material bad facts, which is absolutely not the law. Even if you have an as is, you still have to, the seller still has the duty to disclose the bad facts to the buyer. So as a seller, you can expand the as is. And one of the most common ways that I've seen the as is expanded is for the seller to add a release of claims by the buyer against the seller for any claims that arise from the purchase and sale contract or the property itself. For example, the physical condition of the property's compliance with applicable laws, the property's any environmental problems, and that's often combined with a waiver of California Civil Code 1542, which I've seen more often than I would think would be acceptable in the market. But that's quite often I've seen the sellers are able to manage to get that, and it's often negotiated to push back on. Obviously, the law doesn't permit release of claims that are based on fraud and things of that nature, but you also carve out breach of seller's representations and warranties and covenants from these waivers. From the buyer's perspective, sometimes buyer try to beef up or strengthen the seller's warranties by asking seller to represent a warrant regarding the mechanical or physical defects in the property. For example, the building systems, that they're in good operating order. And usually the sellers resist this kind of warranty regarding matters that a buyer can discover by its own due diligence. And typically sellers are willing to warrant things that a buyer could not discover by its own independent investigation of the property, or going to the city, or doing whatever kind of due diligence that is necessary. So let me go on to the next topic, the assignment. This is a section 1.1. This is our contract is very, very favorable to the buyer. Basically, it gives the buyer the right to assign the contract. It doesn't release the buyer. The sentence in the contract is basically declarative of existing law. In other words, contracts are assignable and the assignor is not released. From the seller's perspective, the seller may require an assumption by an assignee, and in fact, the law is that a buyer who wants to sue for a specific performance has to assume the contract. So the assumption is not in the contract. You can add that. The seller can also absolutely prohibit an assignment. And one of the things that burns sellers is if a buyer makes an assignment and makes money on flipping the contract. And that gives the sellers a lot of remorse, because they see somebody who, for example, didn't own the property as long as they did. Now they made a hefty profit over a short period of time. So a lot of sellers would try to prohibit the assignment. If you do prohibit the assignment, then you got to deal with, are you going to permit some kind of assignment? And then what's the standard that's going to be applicable to seller giving the consent? Is it going to be arbitrary or reasonable? If there is seller financing, then there may be a separate independent justification for the seller to want to require that the buyer obtain the seller's consent for the buyer to assign the contract, because the seller may not want to finance anybody, even though there is, in California, we have the one action rule and we have the anti-deficiency statutes, which basically, gross summary of it, if the seller can only sue for, can only foreclose on the property, I can't sue for the buyer for any deficiency if the buyer doesn't pay the loan. Our contracts provide the seller with the right to approve of a buyer's credit and financials in case there's seller financing. A typical carve out for a buyer to be able to assign is to its affiliates, for example, an LLC that's owned by the same principals that are transacting to buy the property. Access to the property is something that you need to think about if you're doing an environmentally potentially concerning property. So an industrial property is usually when this issue comes up. Our contracts say that the buyer can't do any invasive testing without the seller's consent. And the problem or the dilemma is created by the fact that the buyer will do a phase 1 report, which will now say you need a phase 2, but the buyer can't do a phase 2 without the seller consenting. And our contract says that the seller has to consent reasonably. But the seller may not want to find out about the potential environmental problems with the property, not knowing whether the buyer is going to buy or not. On the other hand, the buyer is the one who's spent money doing a phase one report and doesn't want to have the situation where they've reached the point where there's a potential environmental issue that needs to be resolved by further investigation, but the seller won't permit the buyer to do that. Now you're at a standstill. So our contracts say the seller can't be unreasonable in granting the buyer's request to do invasive or destructive testing. As a buyer, you may want to get the seller to consent upfront, especially in an in an industrial deal where you think you might need to do a phase two if the phase one recommends it. So you can get the seller upfront to say, okay, I'll let you do a phase two to the extent that it's recommended by phase one. From the buyer's perspective, you also want to maybe add something that says buyer's not responsible for discovering any pre-existing environmental contamination, so long as the buyer doesn't aggravate that situation. A typical ad that I see is the sellers will add a requirement for the buyer or buyer's environmental engineer to have insurance. They have CGL, commercial general liability insurance that names the seller as an additional insured, E&O insurance, auto liability, and workers' comp insurance. Those are pretty typical ads that I see if somebody's very concerned about this issue. So let's talk about liquidated damages and remedies. The earnest money deposit is often the liquidated damages in the contract, and our contracts have a provision for liquidating damages to a seller in case a buyer breaches and doesn't close. Our contracts do not require mediation before you litigate or proceed with resolving the dispute over liquidated damages. Our contracts do include an arbitration provision in addition to the liquidated damages provision. By the way, as most of you know, both of those have to be separately initialed for them to be applicable. The arbitration, however, only applies to the disposition of the earnest money deposit. In other words, does the buyer get it or does the seller get the earnest money deposit? If you're a fan of arbitration, you can broaden the application of the arbitration provision to apply to all or more disputes. From the seller's perspective, it's not uncommon for a seller to establish a deductible for buyer's damages for seller's breach of its warranty before the seller becomes responsible. In other words, if there's a breach of the seller's warranties, the buyer has to suffer at least, for example, $50,000 worth of damages before the buyer can proceed against the seller for breach of seller's warranties. That's common. That's very commonplace. Conversely, the seller can also put a cap on the seller's liability for breach of warranty. The argument typically goes that like this: well, the buyer has put in usually a 3% of the purchase price as earnest money deposit, and the contract has a liquidated damages provision, and it provides that if the buyer breaches the contract, then the seller can get the liquidated damages, and that's the extent of the buyer's exposure for breaching the contract and not closing. So the seller's argument is that I should be able to put a similar cap on my liability for my breach of the contract. This is a breach of the warranties, not a failure to convey title. And this will range, depending on the property type and the leverage and the price, it will range from a low of 1 or 2, 3% to 5, 10%. But the cap on the seller's liability is an important provision to protect the seller in case there are extensive warranties. Another protection for the seller is to have the buyer waive the right of specific performance or add reciprocal liquidated damages for seller's breach. Now, buyers seldom agree to this because this allows the seller to sell the property from under the buyer. And if a buyer enters into a contract to buy a property, they're intent on buying that specific property. And I've not seen too many buyers who are willing to agree to either the waiver of the specific performance or reciprocal liquidated damages for breach. Let's talk about the protections that are in the contract for the buyer, for the broker, sorry, the protections that are in the contract for the broker. As you know, AIR is a broker organization. We don't make a secret of it. The contracts are printed to protect the brokers, and some of the protections in the contract I'm going to highlight here so you can make a note of all these provisions to strike. If you're representing the buyer or the seller. Section 7.1, the last sentence says that the buyer will use the buyer's broker exclusively for negotiating any deals with this property for 1 year. This was really meant to be a prophylactic provision to prevent a buyer and a seller colluding with each other near the end of a listing to say, you know what, don't respond to my offer. Let's wait till the listing expires. Then I'll come back and we'll make a deal and we'll save the commission or we'll split the commission. That way we can avoid paying the buyer's broker or the seller's broker or any broker at all. So this is meant to prevent a buyer and a seller colluding with each other to run out the clock on a listing and then make a deal without the brokers. What's happened in California, we had the AB 2992 that became effective January 1, 2025, which requires every broker representing a buyer to have a buyer-broker representation agreement. That's the law now. So this is less of a concern for the buyer's broker because they will be protected by the buyer-broker representation agreement. Most seller brokers have a registration period in their listing agreement, so this may not be as critical with the passage of AB 2992 in California.
So Brian, we have 3 slides and about 4 minutes of the
I'm almost done here, Howard.
Great.
So section 9.1 is the payment of the commission at the closing. This is very often stricken. And it doesn't really, that's very often happens. The next one is section 18.1. This is important. The party who defaults has to pay the broker the fee that the broker would have been paid. If the buyer is the defaulting party, the buyer owes the broker's fee in addition to any liquidated damages. So this is a very important provision to pay attention to, 18.1. 24.1 is 2 provisions. One is that says that the reduces the statute of limitation for suing the broker to 1 year after the date of agreement and puts a cap on the amount of the broker's exposure to the amount of the fee that was received by the broker from the transaction. So I just wanted to highlight these for people to kind of have it in one place. So with that, Howard,
Great. 1 or 2 other things. Someone was asking a question about the seller can only foreclose what statute or case. I'm not sure I recall exactly what that related to, but is there some limitation of the remedy to foreclosure?
So in California, we have what's called the one action rule and the anti-deficiency statutes, which are very complex, but generally speaking, if a seller finances part of the purchase price by taking back a note secured by the property that the seller sold, if the seller forecloses and there's a shortfall, the seller can't sue the buyer for a deficiency. That's the anti-deficiency statutes and the one action rule, very generally speaking.
Mm-hmm. And one gentleman says that when he represents sellers, he likes to strike out the obligation for the property info sheet and when the property is being sold as is. But they still advise the client to disclose all material facts, but he feels the property info sheet is broader than simply those disclosures.
So deleting the property information sheet is not a way to get around the seller's duty to disclose, as the gentleman is correctly noting. You still, as a seller, have a duty to disclose the material facts of which you're aware, which affect the value or desirability of the property. The property information sheet is very thorough. It goes through every aspect of the property and asks the seller to tell the buyer, does the seller know, for example, the HVAC doesn't work, the roof doesn't leak. So it may not be a material item in each transaction, but the property information sheet is a generic form that's meant to help the seller think about different aspects of the property and was there something that I need to disclose? And it's also, don't forget, it's prophylactic for the broker because the seller is supposed to disclose the defects and it covers the broker's neck too.
Yeah, if I'm a buyer or representing a buyer and I see that stricken, I almost wonder if that's a red flag that they're telling me that there's problems they don't want to tell me about, and whether it's going to make the buyer's investigation and questions to the seller a little more detailed and thorough than they might be if they get the property information sheet.
That's an excellent point. A lot of these contract provisions are meant to be a checklist.
And if you see the checklist being taken out or the disclosures removed, then is it a red flag or isn't it?
Yeah,
You just don't
absolutely.
know.
Absolutely.
So we're actually right at 1:30. We handled the questions. Bryan, always a pleasure. Your knowledge of all this is so thorough, and the way you phrased everything I thought was fantastic. And really appreciate you coming back again this year to do this program on the purchase and sale agreement, and look forward to the next time.
My pleasure. Thank you for asking.
Thank you to everybody for attending. We appreciate it and hope to see you the next few months at our programs for the real estate section.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.